So the floor is yours.
Thank you. A quick spoiler, I have a really minimalistic PowerPoint presentation, and please excuse the poor images. But yeah, just so you be prepared. In the following 20 minutes, I would like to invite you to take a closer look with me at the West Berlin restitution files of Sinti and Roma that are preserved at the Central State Archive Berlin, which is the Landesarchiv Berlin. Yeah. Although these files are naturally shaped by a bureaucratized, formalized procedure, I argue that they should also be seen as important testimonies from Sinti and Roma themselves. Even though over the last 2 days we've discussed restitution proceedings, we have not yet addressed procedural practice in West Berlin. Since the practices differed at the regional level, and in order to better understand these differences, I would like to begin with describing the procedural practice in Berlin. The Restitution Office in West Berlin was established in 1949. It dealt exclusively with claims for restitution of seized possessions. Contrary to the practice of the other federal states, a separate compensation office was established for compensation in West Berlin in 1951. The restitution was first regulated at the local and regional level, and when legislation was available at the federal state level. It was in 1957 that the federal restitution law came into force. The cases I'm going to present shortly were based on exactly this law. The basic requirement for the application of restitution and compensation claims was recognition as a person persecuted by the Nazi regime on racial, political, or religious grounds. For a long time, collective persecution was not recognized for Sinti and Roma. The first federal Supreme Court landmark decision occurred in 1956. This decision argued against the racial motivation of the deportation of Sinti and Roma before 1943, but proclaimed that the deportations after the Auschwitz decree had been racially motivated. Even though it was a setback, the compensation authorities were, in theory, now obliged to pay compensation for the period after the Auschwitz decree. Before the West Berlin Restitution Office initiated the proceedings, claimants first had to submit a registration form. The employees of the Restitution Office reviewed the forms and checked the completeness of the application, whether all criteria had been met. Alone, these registration forms filled out by the applicants or the attorneys can be seen as examples of testimony. They not only provide information about the claimant and injured party, such as their occupation, relationship, and eligibility to apply, co-heirs, and family constellations. But through these forms, claimants also provide insights into the particular context of the property conversation. These insights are not just about the possession itself, but also about the place and date of the conversation. In these cases I'm about to present, the property was seized in the scope of the Berlin deportations in the context of the Auschwitz decree in March 1943. By then, all persons were either already imprisoned in Zwangslager Berlin-Marzahn since 1936, or were temporarily imprisoned there sometime before their deportation. The Zwangslager Berlin-Marzahn was a detention camp for Sinti and Roma that was located around 10 kilometers northeast of the city center of Berlin. Marzahn is now the district of Berlin. When looking at the date given in the registration form, it is important to remember the context of the Federal Supreme Court decision, which I just mentioned earlier. Again, this was the decision that proclaimed that only the deportations that occurred after the Auschwitz decree were considered racially motivated. Any claims relating to imprisonment and deportation before the decree would be per se have been considered unfounded. The present cases involve different forms of testimony. The most common form is the affidavit, or in German, eidesstattliche Erklärung. Various types of affidavits can be found in the restitution files. Of course, not only in restitution files, but also in restitution files. First of all, these files contain declarations by applicants in order to make facts credible to the restitution authority in order to be granted inheritance rights. In addition, the office ordered affidavits from external witnesses. A notable aspect was that the claimants had to pay the cost not only for the attorneys. If they wished for a positive outcome of the proceedings, they were required to cover the costs of obtaining and notarizing the affidavits, as well as for other documents and copies. Thus, while looking at the following examples, one should keep in mind that these costs alone were already a hurdle, and particularly precariously situated persons in some cases were not even in the position to file an application at all. Next slide. In 1957, August W., a pensioner, filed a claim for restitution on behalf of his parents. He applied for compensation for his parents' caravan, including furnishing. The restitution office offered August a settlement of 400 mark 5 years later, justifying it on the grounds that the caravan had already been 18 years old. And the offer served the interest of settling the case more quickly. Next slide. While we learned from August's registration form that he was the only son of his parents who were deported from the detention camp Berlin-Marzahn to the Auschwitz concentration camp, where they were murdered, it is the affidavit where August testifies about the events that seem most important to him. So this is a little extract out of the registration form, which I mentioned earlier. In the unusually long, detailed statement, he also describes the time before 1933. Just like his father, August traded in musical instruments. He testifies that his father taught him how to repair instruments and passed on his skills to his son. This passing on of knowledge from father to son can be seen as an aspect of family history. Regarding the period during the Nazi regime, the importance of the police takes a significant role in his affidavit. He reports, for example, about the police civilians in the detention camp Berlin-Marzahn, or how the family's caravans were taken away from them against their will, and how they had to move into a more strictly guarded barrack on the side of the camp. Again and again, he emphasizes the strict police control and the involvement of the police in the persecution measures. August also testifies that he fled the camp out of fear of being deported after his parents were deported to Auschwitz concentration camp, and how he subsequently lived in hiding. With the help of the worker, Mr. Jung, and his wife, he was able to survive. The affidavit is obviously intended to make facts credible to the restitution office. The framework of the testimony is thus clearly set. Nevertheless, August provides individual details and is able to present himself as a self-determined subject who resisted the Nazi practice of persecution. You can actually go one slide forwards. Yeah. This is particularly significant because in compensation proceedings, the persecuted are usually characterized only as victims without any agency. Next slide. A similar picture emerges in the case of Margarete M. In 1957, Margarete M. filed an application for restitution of the property seized from her deceased father. He was interned in the Berlin-Marzahn camp as well, and in the concentration camp that was located 30 kilometers north of Berlin, among other places. The place and date of his death are known. Margarete M. died in the course of the proceeding, and her husband, Hugo T., and her daughter, Jutta H., continued the proceedings. In 1975, so just a reminder, the application was filed in 1957. In 1975, the application was ultimately rejected. The rejection was justified on the ground of unclear inheritance circumstances. Instead, the restitution office proposed a settlement payment to the applicants, which they accepted. In her affidavit, Margarete M. describes how her father was deprived of his caravan and other assets before deportation. Right at the beginning of the statement, Margarethe M. makes it clear that she is acting as a secondary witness when describing the conversation, since she was not present at that moment. Next slide. Furthermore, she reports that after finding out about her father's deportation, Margarethe M. immediately went to the local police station to speak with her father and to take custody of the valuables. So this is a short picture of the affidavit, exactly when she was talking about how she tried to get the valuables. And not only did Margarethe M. resist the police expropriation, she also put herself in danger of being arrested herself. Similar to August, Margarethe M. then went into hiding to avoid her deportation. This affidavit also provides significant evidence of agency and resistance by Sinti and Roma during the Nazi period. Next slide. Next slide. Yeah. No, one back. We find another important form of testimony in Margarethe M.'s proceedings. In some cases, the claimants themselves approached the restitution office. For instance, they would contact the restitution office to inquire about the status of the case, or to report changes of address or attorney, or to just move the case forward by restating the situation. Margarethe M.'s daughter, Jutta H., wrote a handwritten letter a few years before the end of the proceeding concerning her grandfather's property. Her mother, Margarethe M., had already passed away. What particularly stands out about Jutta's letter is that it has more the character of a note, which is pretty unusual for a letter to an authority. It is written on 2 sheets of paper, torn from a notepad without any form of address or greetings. The author expresses her anger in the letter, which is characterized by many careless mistakes and seems to be written in a haste. First, she criticizes the restitution office for doubting that her grandfather belonged to the minority of Sinti and Roma. In reference to previous letters from the restitution office, Jutta H. testifies to the persecution of her family members. She compares the Nazi persecution to the hunting of animals. Next slide. With statements such as, quote, "Why do you keep coming up with new questions," unquote. Next slide. And, quote, "Or do you want to dispute my inheritance where people gave and had to lose their lives for?" The author concludes by implying her criticism of the intransparent bureaucratic procedure. Next slide. With the note, Jutta not only testifies to the persecution of her family, she also shows the fallibility and problematic bureaucracy of the restitution office. The testimony presented here thus has 2 layers of time. So the first layer of time is the Nazi period, and the second layer of time is either 1950s, 60s, 70s, so basically the time period of the compensation proceedings. By disregarding procedural rules that had not been laid down but were generally accepting, like the communication through her lawyer, she actively advocates for her own interests. Consequently, the letter must also be seen as a testimony of self-empowerment. Lastly, I would like to address another figure already mentioned, the applicant's attorney. In addition to the procedural correspondence, the attorney drafted letters describing the facts at hand. They reproduced what their clients told them and tried to contextualize the information in order to achieve positive outcome. This practice can also be seen as a form of secondary testimony. Next slide. For instance, in the case of Palma B., who filed an application for restitution of her parents' property in the year of 1962. 2 years later, in 1964, the application was granted and she received a sum of 1,500 mark. Her attorney, Proskauer, describes in a letter that her husband managed to prevent her from being stigmatized as a gypsy for some time. According to Proskauer, due to intensifying persecution, this was no longer possible. In order to avoid deportation, Palma had to agree to a forced sterilization. However, the procedure was never carried out. because the war ended a short time later. Proskauer further reports that Palma B., who lived in an apartment with her German husband, never again entered the detention camp Berlin-Marzahn after her parents were deported. The reason for this is her, quote, instinct for self-preservation. Finally, he also points out that all of her family members were murdered. Next slide. Because the file is incomplete, the attorney's letter is one of the few testimonies to Palma's story. So this is exactly the paragraph where the attorney refers to her affidavit and also to communication with the restitution authority before. But as I had the file lying on my desk, I could see that the file was only contained 5 pages and no affidavit. And this is also like the reason why I could say, okay, it's not complete. In order, one second, finally, he also points out that the families were all murdered, as I already said. Because the file is incomplete, the attorney's letter is one of the few testimonies for the story. The letter of the attorneys, however, cannot be equated with the testimonies of the members of the Sinti and Roma themselves. The reason for this include the fact that the relationship was one of dependency, that the lawyers themselves mostly belonged to the majority society, and that they were usually simply interested in bringing the case to a close and not necessarily in supporting Romani voices. Some of these letters were even characterized by anti-gypsy resentments towards their clients. It would be, I believe, a fruitful task for future research to elaborate on the role of these attorneys. Next slide. Coming back to Romani voices, I would like to close with thoughts on the potentials of these files. So restitution procedures are complex and highly bureaucratized, and the individual testimonies cannot be seen outside of their context of origin. Affidavits, for example, are determined by the facts they are intended to give credence to. And as Barbara has already shown yesterday, narratives in these testimonies can also be purposely made up. This is clearly a pitfall. Yet restitution proceedings provide us with valuable historical sources that can reflect the perspective and action of the persecuted themselves. This is especially important in the case of Sinti and Roma, where other testimonies are often rather rare. And I think this is something Paul Weindling also addressed yesterday. The presented testimonies can shed light on how Sinti and Roma perceived their persecution and what measures they took against it. This can address themes that go beyond the formal boundaries of the restitution proceedings. Thank you.